Hello, ladies and gentlemen, meine Damen and meine Herren. As we are gearing up for the holiday season, we would like to welcome you to another episode of the UPC Insights, where we break down the latest developments at the Unified Patent Court and discuss their implications with leading experts. I'm your host, George Walden. I'm glad you could join us today, and we're diving into an especially fascinating area of patent law, infringement based on the doctrine of equivalence. This is a topic that has sparked much debate in the legal community, and with the recent UPC decisions advocated by the Hague division, it's more relevant than ever. And to help us explore this issue, I'm thrilled to welcome two exceptional guests. Joining us today is Sam Giles, a UK and European patent attorney with extensive experience in complex cross-jurisdiction cases, also known as the man with the plan. Sam, welcome to the party.
Hi, George. It's nice to be back.
Nice to have you. Alongside him, we have Mr. Tilman Pfrang, a German attorney and a regular contributor to the UPC Insights, who brings us his deep knowledge of UPC practice and case law, also known as the original OG of the UPC. Tilman, welcome to the show.
Hi, George.
Together, we'll compare the UPC's recent decision with the national practices in the UK, Germany, and the Netherlands, and unpack what this means for patentees and defendants alike. So, gentlemen, are we ready to get started?
Yeah, let's go.
Okay, yeah, let's go. That sounds good to me. Tilman, to start us off, could you please explain to our listeners the doctrine of equivalence as it applies within the framework of the UPC, and how does the doctrine influence the way patent infringement is assessed?
Yeah, certainly, George. The doctrine of equivalence is based on Article 69 of the European Patent Convention, so the EPC in the end, and its accompanying protocol. This idea shall ensure that patent protection is not limited to the strict literal wording of the claims, but also extends to equivalence. So elements that, while not explicitly mentioned in the claims, perform substantially the same function in substantially the same way to achieve substantially the same result.
Good. I think I can understand that a little bit. Hopefully our listeners will too. So then explain the next situation. Could you discuss any recent UPC decisions that have shaped the application of the doctrine of equivalence, and what insights can these cases provide about the court's direction on the issue? Now, this will be good.
Yeah. So far, as far as I know, we have exactly one case dealing in detail with equivalent patent infringement. It's a decision or recent case of the Hague division of the UPC. Mm-hmm. In that case, literal infringement was denied, so that the court had to deal with a potential equivalent infringement. Precisely from a technical perspective, the claim of that case defined the location of the roots of a plant relative to an anode compartment. And exactly, of course, this feature was not literally fulfilled in the alleged infringed product. Precisely then, the local division, the Hague, how the doctrine of equivalence might be applied in practice, and worked out the following head notes. They said the test applied to the assessment of infringement by equivalence is based on the case law in various national jurisdictions. So that's interesting that they explicitly refer to the national jurisdiction. And this would be proposed by both parties in this case. And they continued by saying that this entails that a variation is equivalent to an element specified in the claim if the following four questions are answered in the affirmative. We need technical equivalence, they said. So does the variation solve essentially the same problem that the patented invention solves and performs essentially the same function in this context? Then they required a fair protection for the patentee. So they ask, is extending the protection of the claim to the equivalent proportionate to a fair protection for the patentee? Also, they considered the other side. So they said we need reasonable legal certainty for the third party. So does the skilled person understand from the patent that the scope of the invention is broader than what is claimed literally? And finally, they said, or they asked for, is the alleged infringing product novel and inventive over the prior art?
Okay. And for our listeners, it will be intriguing to understand how this decision aligns with the case law from national jurisdictions. Considering this case was adjudicated before the local division of the UPC in the Netherlands, can we expect similarities between the UPC's approach and the traditional Dutch legal practice? How about that?
Yeah, absolutely, George. I mean, we can expect similarities. There are considerable similarities. And if I may say that or add that, in many other areas of the UPC, in many cases where the UPC had to deal with a new question, the competent local division was, of course, not unwilling to consider the national practice. In that case, one must say that Netherlands have been long recognized for their progressive application of the doctrine of equivalence, often embracing a rather pragmatic approach that ensures substantive justice, I would say. A very famous case, which also played a role in the UK, we come later to that, or in Germany, was the so-called Eli Lilly case in the Netherlands, which reflected a broad interpretation of equivalence. Rather generous approach, I would say.
So,
And the Hague division in the UPC case at hand, the one UPC case we have so far, seems to mirror this tradition. You see that, for example, that they more or less raised the same questions as they did in the Eli Lilly case.
so you think it's a developing pattern or so?
Yeah.
So, ladies and gentlemen, we get to interview Sam Giles. Sam, I got a question for you. We saved the best for last. I'm sure Tilman would disagree, but anyways, we're going to go for it anyways. Sam, give us the importance of understanding regional differences. Could you discuss how the UPC decision reflects or diverges from the established UK case law, especially in the terms of handling patent infringement claims under the doctrine of equivalence?
So we have the doctrine of equivalence in the UK, and we have since, effectively the same case that Tilman just talked about. It reached the UK Supreme Court a little bit before it reached the same stage in the Netherlands. So we've had our test in there a little bit longer than the 4 questions used in the Netherlands. But the actual questions themselves are slightly different, even though they're for the same purpose. At this point, I might just say that I vehemently disagree with the doctrine of equivalence and its use.
Okay.
Personally, I think that purposive construction is a far better way of assessing the scope of a claim. I agree with the protocol and the interpretation that Tilman's already talked about, and that obviously means that the scope of protection isn't bound by the literal wording of the claim.
Okay.
Under purposive construction, which was the UK approach beforehand, you would decide what the claim terms meant. And this comes from a case, probably originally from a case called Catnick, which was about lintels and the term perpendicular, I think, and about what the meaning of 90 degrees was effectively. And someone had come up with an alleged infringement that was 87 degrees or something. And although that isn't within the literal scope, it was found to be within the purposively construed scope. And I think that's how claims should be interpreted, personally. Unfortunately, the UK Supreme Court disagreed with me. So
why could that be, I wonder? Okay.
So effectively, this case was all about a drug that dealt with cancer, and it was about a salt. So in a salt, you've got the Permatrax part of the salt in the claim, and then you've got the metal that's attached to. So in the claim that was being brought, it was about specifically had sodium, whereas the alleged infringing product had dipotassium. Now they're obviously different, but they had the same function, because once the salt is dissolved, the Permatrax is free, and so you have the same effect. So in the UK, at first instance, there was found to be no direct infringement and no contributory infringement. At the Court of Appeal, it was found there was no direct infringement, but there was contributory infringement. And I think that judgment was sound. I think that there was contributory infringement because you were creating the same salt, the same thing once the salt was dissolved.
Right.
But I don't think there should have been direct infringement. And then in the Supreme Court, they completely changed UK practice and introduced the doctrine of equivalence and found that there had been direct infringement. So this means that UK test is, as such, it says, does the variant infringe the claims as a matter of normal interpretation? So that's under purposive construction. And then the second part is, if not, does the variant nonetheless infringe because it varies from the invention in a way or ways which is or are immaterial? And the way that you assess whether that variant is immaterial is to go through the three equivalence questions. So notwithstanding that it is not within the literal meaning of the relevant claims, does the variant achieve substantially the same result in substantially the same way as the invention? Would it be obvious to the person skilled in the art reading the patent at the priority date, but knowing that the variant achieves substantially the same result, that it does so in substantially the same way? And then finally, would such a reader of the patent have concluded that the patentee nonetheless intended that strict compliance with the literal meaning of the relevant claims of the patent was an essential requirement of the invention? So we have a similar test, but effectively it is substantially the same result in substantially the same way, and then was there intended strict compliance? So if in the specification they said it's essential that you use sodium, there wouldn't have been found to have been equivalence. Whereas because they didn't, it was found that the claim should be construed more broadly.
Well, so bringing that in mind, so you were disappointed with the verdict from that side. I'm going to go to Tilman. Tilman, how about how is it in Germany?
In Germany, it's again a little bit different. In Germany, also this Eli Lilly case, or as we call it, Pemetrexed, is one of the most famous cases in total. Interestingly, also the German court, by the way, confirmed infringement, equivalent infringement in that case, as the Dutch and UK court did. And also, if you have a closer look into what the court in that case and in similar infringement cases actually said, it is not so far away from the Dutch perspective and also not so far away from the UPC's perspective now. Also, the German courts would ask whether or not there is the same effect. So equivalence in a technical sense. That's the first question, by the way, the first question of the UPC division in The Hague. Then they ask as in a second step, is there obviousness over the patent? So they say, well, there cannot be any equivalent infringement if the equivalent means is not even obvious in view of the patent. So it's an invention on its own, at least in comparison with the patent. This is only part of the second question, actually, of the local division in The Hague. But interestingly, this is also kind of the addition The Hague division incorporated compared with their local practice. So this requirement I could not find in the Eli Lilly case of the Dutch court. So second requirement in any event in Germany would be the obviousness over the patent. The third requirement is always the most difficult to explain. There are different wordings for it. Former days, it was more like a parity or equal validity. I don't know how to translate it more appropriate. And nowadays, it's more like that there is the so-called requirement of the claim orientation. So any considerations must be based on the wording of the patent or patent claim. In the end, this is more or less kind of at least I would say, a safety net for the court if they say, well, we have the same effect. It's obvious over the patent, but it's so remote from what the patent actually teaches that we cannot say it's covered by the protection of the claims.
So, like Sam was disappointed with the UK ruling, have you been disappointed with any of the German rulings? To this effect and this?
That's a good question. Actually, not so much. I always have exactly with this requirement, claim orientation, as we call it. I have my difficulties. There are some lines of case law where it is rather clear what's meant and how you should decide a case. I mean, very famous case is Okklusionsvorrichtung, which more or less says, well, if the equivalent means is explicitly mentioned in the description, but not mentioned in the claim, then there is no equivalent patent infringement. This is an example where this third requirement played a role. And finally, by the way, also in Germany, like a fourth requirement, we have the so-called Formstein objection, which means that there cannot be infringement if the alleged infringed product is obvious in view of the prior art.
Okay.
So the scope of protection ends where the prior art begins, more or less. This is, however, from a procedural point of view, a bit different to the local division in The Hague, and also a bit different to the Dutch tradition, because the defendant in that case in Germany must raise such objection. If such objection is not raised, the court will not consider this. So it's not like a fourth question or a fourth requirement. It is more like a further step which can be triggered by a corresponding objection of the alleged infringer. It's more a procedural issue, but it's important to know.
Okay.
So it's like a defense you have to raise, Tilman.
Exactly, yeah.
Okay. Then what are the strategic implications for patent holders in light of how the UPC handles the doctrine of equivalence, and how should they prepare their patent applications or adjust their enforcement strategies, Tilman? What do you think?
Yeah, well, my advice would be you should draft your patent application in a way that you do not need to argue for equivalent infringement. Because actually, one logic behind this, or at least from a German perspective, one logic behind equivalent patent infringement is kind of a solution if the patent application has not been ideally drafted and or if the prosecution was not ideally handled. So that it's kind of a generous approach of the court saying that, well, we understand no one is perfect. And in that case, we can consider at least equivalent infringement. So my advice, try to avoid that.
Sam, what's your take on it? What are the strategic implications? What do you feel about that?
I think the doctrine of equivalence affects strategy more for third parties than for patent holders. I think patent holders would be looking at infringement regardless, and if you're at the point of assessing infringement, you're already considering whether to take an action. You're already at that point of strategy. Whereas with third parties, if you're trying to, for example, enter a new market or have freedom to operate or anything like that, it makes it very difficult to give certainty and to give an absolute opinion on a set of claims or a whole portfolio. So when it comes to the UPC, we've already seen here that they've pretty much taken the Dutch approach. I think Tilman said there's a slight tweak of a difference, but the Hague division has very much gone with the Dutch approach. And if we do see local divisions following local precedent, you could end up with a little bit of a patchwork. And then how do you give a freedom to operate opinion when a load of local divisions may operate slightly different legal tests, and they therefore may come to slightly different conclusions? We already have that, of course, with national rights, but the purpose of the UPC is to unify, patent enforcement into one action rather than going across multiple EU states. So it worries me that we could end up with a patchwork within a unified system.
Before I ask the last question, is it safe to say that these local divisions are the wild cards of everything? Anything could happen in the local division. Is that what you guys are saying? Or
I would say for the moment that this is also what Sam is saying. At the moment, a lot can happen. We will see more and more harmonization by the Court of Appeal. But for many very crucial questions, and equivalence is only one of that, we don't have any guidance of the Court of Appeal. Okay. And for the moment, I agree with Sam. It's not the ideal situation. Whatever your case is, actually you have to consider also where to go as a potential patentee. This is also maybe good. You can choose the ideal forum or try to choose the ideal forum. But for the defendant side, it's horrible. In past days, we had these national jurisdictions, of course, but at least you could say, well, in the UK, you face these problems under that case law, and in Germany, you face other problems under other case law. But now we have one and the same territory, where different local divisions are competent and seem to apply not the exact same practice. So yeah,
Right.
we will see much more harmonization in 5 to 10 years, but for the moment, it's a very divergent situation.
Very diplomatically put. So looking forward, what challenges do you foresee for the UPC in maintaining a balanced approach to the doctrine of equivalence, and how might this affect international patent litigation strategies in the future? Tilman, take it.
Yeah, I think we have already discussed a little bit this question. In the end, a lot will depend on the Court of Appeal. I expect that the Court of Appeal will have sooner or later several cases also regarding equivalent patent infringement. I mean, the first case might be now the case the Hague division handled.
Okay.
If one of the parties appeals this decision, and let's hope the losing party in that case appeals the decision, then we will have a first case maybe or first decision of the Court of Appeal in 1 year. And then I'm looking very much forward to the direction and the guidance of the Court of Appeal, actually. Interestingly, the Court of Appeal has 2 panels for the moment, and one is led by a German judge, the president, Grabinski, and the other one is led by a Dutch judge.
Okay. We're all laughing here, but why are we laughing?
So let's hope that we will not have another layer of divergence, that whether, depending on which of the 2 senates you are actual panels, you have your case, that the Court of Appeal would go in the one or the other direction. More difficult for the patentee would be, by the way, that you cannot govern in any way which panel of the Court of Appeal will be competent for your case. So let's hope that they are in close communication with each other and that we have a nice and harmonized case law in the
Sam, do you have anything to add to that?
What would be really useful is
here we go.
The Court of Appeal, when they get the first doctrine of equivalence case, sets out in quite a lot of detail how they want these cases to be dealt with going forwards, because there are lots of different questions. We've touched on the actual questions regarding the doctrine of equivalence, which are the most important part. And you've got the UK questions, which are slightly different, the German questions slightly different, the Dutch one's slightly different, and whatever formulation the Court of Appeal eventually settles on, that will dictate how it's dealt with in the future. But there's other matters like, is the prosecution history going to come into play, or should you ignore it? Various other things like that. And it would be really good to get quite a wide-ranging guidance on something that's quite so fundamental to the assessment of infringement. And the sooner we get that, the better.
Okay, sounds good. Well, folks, so that's going to wrap it up for this edition of UPC Insights. I'd like to thank both of our guests, Tilman Pfrang, Sam Giles, for a very interesting and, as usual, very insightful conversation with you guys. And then I'd also like to thank our listeners for joining us. And I also like to say, if you guys have any ideas for our listeners, please feel free to enjoy our content on our YouTube website, or going to our website at www.meissnerbolter.de or .com. You can hear a lot from these gentlemen on further cases in the past and also in the future. We look forward to having you guys back again. Happy holidays, and auf Wiedersehen.
Auf Wiedersehen.
Thank you. Goodbye.
Bye.
Goodbye. Bye-bye.